Is that you?
No, I'm the chair of the Welcome Republicans. The attorney for Mr. Munoz and the party is John Paul Ivec, I-V-E-C.
Thank you.
You're welcome.
Do you have any agendas? Do you have any agendas, copy of the agendas?
I have them all, but I don't have copies of them, so if we can get copies made, I can pass those out for you.
JP, where do you want me? Okay.
Sorry. Good.
Do you have one I can take?
Say again?
Can I give you a copy of my appearance?
Certainly.
This is my appearance and the motion to disqualify.
Brandon, let me take a picture of this.
I didn't see you.
Did recognize me?
And then once we get started, so
That's what I'm sorry. Can you restart that?
Yes, ma'am.
Okay. So it's that one kind of like yours.
We will set that date today. Sorry.
No,
This will be because yesterday. But the state attorney, she was a service. Yeah.
It was YM. What do you call me Mr. Files for? I'm sorry,
Yeah, this year's ago, our kids went to school together. I've covered cases with them. All set.
Great. I hereby call to order the Will County Officers Electoral Board pursuant to the call from my office on Friday, June 5th. This call was sent to the county clerk, sheriff, and treasurer. The three purposes of this initial meeting are to set a time, date, and place for the hearing on the objection filed by Richard Jurat to the nominating petition of Rick Munoz as a Republican Party candidate for the nomination to the office of Will County State's Attorney. Adopt rules that will govern these proceedings and accept any preliminary motions that are offered from either party. Mr. Counselor, please call the roll.
Lawrence Staley Ferry, County Clerk.
Here.
Tim Brophy, Treasurer.
Here.
Brian Conser, Sheriff. Here.
We have a quorum.
Can I ask for a sheriff? Who was the third person?
Brian Conser.
Brian Conser, the sheriff designee.
The sheriff designee.
I'm sorry.
What's the sheriff?
We can if you'd like.
Sheriff never part of the electoral board.
We're going to go ahead and say the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The Will County Electoral Board has a set of proposed rules. A copy of the rules will be distributed to everyone for review. Does everybody have the rules? Please take a few moments to review the rules.
What's that?
Do you have another copy?
That was the last one.
I'm looking on the agenda and I see that. About adopting rules. You can't adopt something that's not on the agenda.
Are there any comments or questions from board members concerning the proposed rules?
No.
Do I have a motion to adopt these rules for this hearing?
Motion.
Second?
Point of order. There's nothing on the agenda for adopting rules, so you can't motion and accept anything. Show me on the agenda. I took a copy of the agenda. Motioning for adopting rules is not on the agenda. You can't adopt something that's not on the agenda.
County Clerk, if I could. Chuck Pelkey, I'm the Chief of Staff with the County Clerk's Office. What they're following right now is a precedent that's been set by, prior electoral board hearings that have been held, in the past. In addition, the call serves as the agenda in this case. They're going to move forward with these three issues, so.
Are you their legal counsel?
I'm not.
The Open
The
Meetings
legal
Act,
counsel is not here today. We have special legal counsel, but this is following precedent for prior electoral board hearings.
the Open Meetings Act requires any action taken be listed on the agenda. There's nothing on the agenda, which is the call, that says you're going to adopt any rules.
We're going to have to move forward.
So you can't adopt any rules. I mean, we can argue this out before the next hearing if you want, but we're going to push the issue. If it's not on the agenda, you cannot adopt it, period.
Madam Clerk, please. I understand there's people in the public that want to participate, but the only two people that have filed appearances in this case and are legally entitled to address the board are the counsel for the objector and counsel for the candidate. And I understand there's a debate in the gallery, but frankly, I don't think that's appropriate unless they want to file an appearance and have standing before this board. I think by statute, and it is presumed by statute, because this call is made pursuant to statute, that the board has to, and the people here should be advised, that board rules would be adopted pursuant to statute under the election code. So therefore, I think it is appropriate that the board do adopt these rules pursuant to statute. This call was made pursuant to the election code, and as a board, you are not only entitled, you're statutorily required to adopt the rules. Regardless of what the call says. The call says what cases are going to be called. And with all due respect to the audience, they don't have standing to make comments during the hearing.
Chairman, I'm trying to keep the board from committing a Class C misdemeanor by approving items that are not on the agenda. That's a statutory requirement to put something on the agenda. It don't matter what the election code says. This is a public meeting, and it must be put on the agenda. It's a statutory requirement, and violations of the Open Meetings Act are a Class C misdemeanor.
Madam Chairperson.
You do what you want.
Madam Chairperson, I move we adopt the rules as distributed and shared.
Thank you, Mr. Kanzer. I think we have a motion and a second. Mr. Kanzer, please take the roll.
Ms. Staley Ferry,
Yes.
Mr.
Aye.
Brophy,
Yes.
Mr. Kanzer, myself, aye, yes.
Motion carries. The rules have been adopted.
Chairman, could you advise when you're going to have public comment for this public meeting?
At the end.
Thank you.
In reference to the pending objection, is the objector petitioner present?
Yes. I'm the objector. Yes, the objector is present by Joseph Cerrugal and Scott Piles, his attorney. The objector is not physically present in the room.
Your names have been placed on the record. Is the candidate present, Rick Munoz, and are you represented by counsel?
If I may, my name is John Paul. I have asked leave to file my appearance for both Mr. Rick Munoz, also for the Will County Central Republican Committee. Judge, also, I filed a motion to disqualify, which I believe, before we do anything else, Judge, it's appropriate to deal with that motion.
If there's been a motion, I haven't gotten it.
So this hearing today is to, at this time, we accept preliminary motions by either party, and we set the time to reconvene, which is where we'll hear
The problem is,
further arguments.
as long as you're still on the board, you create a situation where maybe unwittingly, you're going to invalidate any decisions that you make. Okay, and so I believe this motion is timely made. I think the case law is clear that when we make this motion, that if you don't grant it, that this hearing should stop, and one of your members should go to the chief judge to ask for an appointment.
Madam Chairperson, may I be heard in opposition to this motion?
Yes.
Counsel for the objector is essentially asking you to disqualify yourself from being a member of your statutorily required board just for the mere fact that you accepted these petitions. The only germane issue in this hearing are what is contained within the objector's petition. The objector's petition raises one objection. And the question on that objection is whether or not it's a legal issue. Is whether or not somebody who voted in the 2020 Democratic primary here in Will County is entitled to run as a Republican candidate under the election code. That's it. We're not questioning there's no objection relating to the petitions on their face. They're not talking about anything relating to that. So this motion is not well taken. And further, there's got to be some sort of bias or something. The Girard versus Keith case, which was my case in front of the Illinois Supreme Court, is very clear and says there's got to be some basic due process rights at an administrative hearing. However, they have to be germane to what is involved here in this case. One legal objection was made. I don't believe this motion is not well taken. There was no objection to the petitions on their face, relating to when they were taken, or to whether they were bound, or the clerk being a witness in this case because of the format of the petitions. The only objection is whether or not a person who voted in the Democratic primary in 2020 is entitled 2 months later, roughly, to file a statement of candidacy stating that he is a qualified voter of the Republican Party. That is a legal issue and does not mandate the clerk disqualifying herself from being part of her statutorily required duties.
If I may address the board. Mr. Files.
Thank you.
I appreciate Mr. Files' position. I assume that he didn't have time to fully read my petition, because my motion to disqualify does state a basis. The basis is due process, which is the same issue held in Girard. The court in Girard found that respondents, the candidates, have a constitutional right to a fair and impartial board. That if there's bias, if there's an undue risk of bias, that they're entitled to a replacement. And when the board refused to do that in Girard, they got overturned by the Supreme Court. And it's not a harmless error. Judge, in this particular case, alleged in my motion and supported by affidavit, Judge, you are well aware that on June 1st, the clerk's office was notified that the Republican Central Committee would be filing in the afternoon nominating petitions. In that same morning, you appeared before Chief Judge Shainstead with the State's Attorney's Office with a motion for an appointment of a special prosecutor. I've attached the transcript for that hearing. In that hearing, you raised the issue of the need to possibly not accept a potential petition. This motion was filed prior to the Republican Central Committee filing any petitions. It was filed 3 days prior to Girard filing his objection. Judge, the case on point that I believe is relevant, Samuelson versus Cook County Officers Electoral Board, so it is the unique province of the objector to raise issues and objections. An electoral board cannot raise its own objections to nominating petitions sua sponte. That when a petition appears on its face to be in compliance, an election official, which would be you, cannot institute an investigation to determine whether it is in fact compliant. That would usurp power from the board, which is authorized by law to hear objections on nomination papers. Judge, in this particular case, I've also supported it with an affidavit by attorney for the Republican Committee, Ed Rankowski. Judge, that shows in his affidavit the whole process of when they actually filed that afternoon. When they arrived, it didn't take a couple minutes like it normally does. You were there present personally to oversee it, and it took approximately 20 minutes, Judge, in order to accept it. If you read the transcript, your office was somehow aware of the contents and the details of the Girard's petition, raising the issue of Mr. Munoz's voting record, Judge. Again, it's not for the clerk to be an investigative board. And Judge, when you do so, you put yourself on both sides of the issue, Judge. You put yourself not only to judge your credibility here, but also put yourself on the side of, being the objector too. Okay? Judge, bias comes in many forms, okay? And it's this bias that we must weed out. Judge, you were looking for a reason to maybe not accept his petition. You had a concern. You had a concern, what should I do? Judge, you had the information 3 days before an objection was actually filed. So either you're improperly conducting an investigation on your own, or somehow you became aware of Mr. Girard's petition. Judge, it's not that you personally can't be fair, Judge. I'm not saying that, but the public has a right. Mr. Munoz, the Republican Committee, has a right to due process. They have a right that the people hearing this have no taint of impartiality, no taint of bias. And when you went before Judge Shainstead in a secret hearing, ex parte hearing, to investigate what you should do ahead of time, Judge, before it was even filed, you created that bias, Judge. And the proper remedy is to have one of your members go over to Judge Shainstead, or I guess it's now Roger Brickman. Ironically, Judge Stainstead had to recuse himself because he didn't want a taint of bias. His daughter works for Mr. Biles' firm. And even though no one has any objection to Judge Stainstead, we all approve his integrity, he didn't want this proceeding, which is so important to the people of Will County, to be tainted by any hint of impartiality, Judge. And so, Judge, just for the sake of the validity of this board, we'd ask that this motion be granted.
I'd like to, can I have, a clerk has judicial notice of any records in her office. So whether or not somebody voted in the primary or voted Democratic or Republican in the primary, the clerk does have, she's got a notice of the fact of the records in her office and the information that's her record. Now, I can understand Mr. Ivick, who does not typically work in this field, but it is fair to point out to the court that this is not a new situation. In 2012, there was a Democratic candidate for the county board who filed a Democratic statement of candidacy as a Democratic candidate to run for the county board. That candidacy she withdrew her candidacy because there were problems with her nomination papers. Several months later, she attempted to file with the clerk papers to run as an independent. The clerk refused that filing. This is in 2012. Because there was a legal impediment that she may not file a statement of candidacy as an independent candidate, the clerk refused to take the filing. It's not a new situation. It's not novel for Will County. And in that particular case, the candidate then filed a writ of mandamus, which the Will County State's Attorney was involved in because they were representing the clerk's office, which is their job. And both the trial court and the appellate court upheld the clerk's decision to refuse the filing of a candidate who had filed a Democratic candidate statement of candidacy in the primary that was withdrawn, and then attempted to file a statement of candidacy as an independent candidate for the general election. And under 7-43, that was not allowed. In fact, the statute says may not file. The clerk in this particular case allowed the papers to be filed despite that legal impediment. There's no bias here. The clerk has judicial notice of the records of her office. The fact that the state's attorney went in, remembering this case from just 2012, remembering in 2018 there was the exact same situation when the Republicans did the exact same thing here, where a county board candidate filed or voted a Democratic primary ballot in 2018, and then turned around, the Republicans attempted to slate this person that filed as a Democrat, trying to run them as a Republican candidate for the county board. What happened in that particular case, the board met and then the candidate withdrew. They looked at the section of the statute, realized they couldn't do it, and that candidate withdrew. This is not a unique situation. The clerk is a statutorily required member of the board. And every time a clerk takes in their office, whether they're there or not, the statute takes that into account, that the clerk is going to have official notice of what's in her files, and that she takes in the nomination papers as a local election authority. There's no disqualification here. The Girotte case, which is cited by the candidate, doesn't apply here. In that case, the issue was, what were the conditions of the petitions at the time they were filed? And the clerk herself took those petitions in, and the issue in Girotte was whether or not they were bound. That made her a witness in the case, and that's why the court held as it did. Those consequences do not apply here. Secret proceedings, if it was a secret proceeding, how did they get a transcript? Why was there a court reporter there? If it was secret, there wouldn't be a record of it. So the allegation that somehow there's no record and this was a secret proceeding is a red herring. And it's a red herring to obscure the fact that the Republican Party in this case did bottom the voting record of one of the people they're going to slate, and now they're no good. And that's what the issue is. Thank you.
Judge, if I could just briefly respond.
Gentlemen, thank you. I understand your motion. I read it quickly. I appreciate your comments. Scott, thank you for your comments. Look, the fact that this candidate was circulating petitions is public knowledge. The clerk, in the course of her regular duties, her sworn duties, sought advice from the state's attorney and held a public meeting, which was recorded, as you know. In fact, your claim of a lack of due process is illegitimate, as there will be due process for the objection, which we're going to set a date for here soon. And in fact, the clerk did accept your filing, and for those reasons, I move to deny the motion to disqualify. If in order, we can discuss that.
Can we take a 5-minute recess to talk with our special counsel?
That's your call.
Okay.
All right.
Can I have a motion to
Let me
recess?
move-
Motion to recess.
I'll second the 5-minute recess.
Please call the roll.
All right. Lawrence Staley Ferry,
Aye.
Tim Brophy.
Aye.
Myself, aye. Brian Contra.
Carries. We'll recess for 5 minutes.
Chairman, if you could, just when you talk to your attorney, if you could clarify, you have to have things on the agenda in order to act on them. You can't take any action unless it's on the agenda.
Otherwise, it's a quorum. With the report of note,
I don't. Okay. I'm a new to
chairman would
virgin here.
with the attorney. And then Chairman Lawrence Staley Fairley left the room to consult.
Yeah, he got a text from somebody in
We're going to
Sheriff.
go in one at a time, not all of them.
You want me to put what you want?
Yep.
And I'm gonna mark the time.
You guys are recording that in there?
No, it's not a meeting.
This is a meeting.
We're here. That's
If you
not a
go
quorum.
in- She went into,
She's consulting with her attorney. It's private.
she's consulting with the special attorney for the board.
That's correct.
That's not private.
Yes, it is.
No, it's not.
It's privileged.
It needs to be recorded because that's
No,
considered
sir,
a
you're
closed
wrong. I'm
meeting.
sorry, you're wrong.
That's a closed meeting.
No, it isn't. She's in there alone.
Under the Open Meetings Act, it is.
She's in there alone. There's no meeting being held.
Under the Open Meetings Act, it is. The fact that you chose not to go into closed session with her doesn't exempt the fact
We
that...
didn't call a closed session. We called a recess.
I understand
You can
that.
see the two of us standing right here. She's in there alone.
I understand that.
As long as you're here, what provision of the election code allows the sheriff to designate somebody to be on the board?
Say that again.
Huh?
Say that again. I'm sorry.
What provision allows a sheriff to designate to sit on the electoral board?
I'm not an electoral expert. You'd have to ask
There
somebody.
is none, and
Usually it's the treasurer, if the state's attorney, if one of them, the next default is the treasurer.
That's me.
Well,
Okay.
I'll be
He
back.
is the treasurer,
And then the next in line has to go to the sheriff's office also.
How was it?
That's the chain of command. So since the state's attorney recused themselves and the circuit clerk recused themselves, it goes to the treasurer and then the sheriff.
Next elected official.
And
That's
it
what-
just, it kind of follows.
I'm sorry, may I get your name
That was a
because you were
clarification I was
speaking and I
looking
don't
for.
want
I
to
didn't
put you
know
as
who
an
everybody was.
unidentifiable male,
So
but
that
I
is
need
the
your name
treasurer
that
and
you
then the
spoke
sheriff.
and I'm,
identified as John Kraft, K-R-A-F-T. K-R-A-F-T, like the cheese cup. Only I don't know.
I was gonna say, and then, sir, you also spoke as
Yeah,
well.
my name is Kirk, K-I-R-K, last name's Allen, A-L-L-E-N.
Thank you.
Yes, ma'am. I believe that's what it does.
Chuck, don't hang up, I want to.
State's attorney recused, so the treasurer fills in for the state's attorney.
If one of his designees.
Okay, what's your next question?
I said,
I'd have to look it up. I'm just not sure who all has recused themselves.
Court reporter, please note the changes.
I should be the circuit clerk, the county clerk, and the state's attorney. If the state's attorney recused, then it goes to treasurer.
Oh, yeah, it was
yeah, you're right. By the sheriff.
But who recused?
That's if the treasurer.
Recuses.
In county officers elected or appointed by the county. So in the event that any member is a candidate for the office in which objective petition is filed, cannot serve and shall not act as a member of the board, and his place shall be filled as follows. The county treasurer, and he and she is ineligible to serve by the sheriff.
No, not really. I was litigating in case you called.
So we're back to the question, why do we have a deputy on here?
Exactly.
That is not.
So now there's another person in there talking to the attorney? Is somebody recording that?
Could you tell me who was it recused himself off the original electoral board? Was it the state's attorney?
There's always the county clerk, state's attorney, and the circuit clerk.
Circuit clerk. And who recused himself?
Well, the state's attorney
And the circuit clerk.
Oh, and the circuit clerk recused also?
Yes.
Okay. So I guess two, because it, yeah, why did they recuse, you know?
They got legal advice from their attorneys, and they are allowed to recuse themselves if they would like.
Okay, so you had two people recused. That's all I'm trying to figure out is how we got to this makeup.
Yep.
Thank you.
And it's just nice to know.
For instance.
Yep.
So they're doing a round robin in there. No different than James Bones or Jane Eames.
Unless you want, you can start this anytime.
I'm going to ask once again that somebody record that closed session in there, please.
Yeah, it's
They're
a
the
meeting with our council.
Huh?
It's a meeting with council.
Yeah, that would be a closed session. It's no different than chain emails to get something done.
By the way, where's the objector today?
And the chief of staff is in there with them.
Yeah.
Yeah, for lack of a second. Yep.
Back on the record?
Yes, ma'am. Okay. Okay. So we will take your argument under advisement. This hearing today, we will set a time for a new hearing and rule on this motion, on this, motion to disqualify before that hearing. So the reason for the hearing today is to set a time to reconvene. If anybody wants to file a response to that, It must be filed with the county clerk's office and provided to the opposing party no later than 4:30 PM tomorrow, Wednesday, June 10th. We need to set a date to reconvene the hearing. And as I stated, we will rule on this motion then, when our council is present.
Just for clarification, Mr. Piles has before 4:30 tomorrow, he wishes to file a written response, and then we're going to have another date.
I'm sorry.
Mr. Piles has until 4:30 tomorrow to file a written response if he chooses to, and then we're having another date for
Yes,
hearing decision?
correct. Okay. How does Friday morning work for everybody?
Judge, would that be here?
Here? Yes,
9 or 10 o'clock.
10 o'clock. 12.
That's fine with the response.
Is there a possibility we can do it in the afternoon on Friday,
Yes.
1 o'clock?
That's fine.
1 PM.
Okay.
Does 1 PM on Friday work for you?
Absolutely.
I'll move we reconvene Friday at 1 PM.
Motion.
Okay, I have a motion and a second. Mr. Conser, please call the roll.
Lawrence Staley Ferry, County Clerk.
Aye.
Tim Brophy, Treasurer. Brian Constable, myself, aye, Sheriff.
Okay, motion carries. Are there any other comments regarding this proceeding?
Is Friday the hearing? We're doing the hearing on Friday. It's not a date for a decision on this motion. We're actually doing the hearing on Friday. The hearing on the objection that I filed.
That was my motion.
Okay, I just want to
Schedule the
clarify.
hearing on the objection for Friday.
Okay,
Just for clarification, so before Friday, you're going to have a decision on my motion to recuse.
Friday,
Friday, we're going to have it.
we will have it.
And then are we going to set it then for a hearing on the objection afterwards? Or have you already made up your mind that you're going to not recuse yourself?
What?
Is he on the
I can't hear you.
We will make that determination on Friday.
Sure. But presuming that you haven't already prejudged this, presuming that, if you make the decision, then we should set it for a hearing on the objection some short date afterwards.
well, if I may, I'm assuming you haven't prejudged this because you've asked me to file a response to it. And I'm assuming that the Madam Chairperson would like to review both his motion and my response before making it. So obviously, that begs the question of whether or not you prejudged it if you're asking me to respond.
No, but Mr. Miles, if the decision is on Friday, and then they're going to call immediately the hearing, if she recuses herself, we're going to have to get another person, there's going to be another date. What makes sense?
We'll have a replacement in the room, if that's the determination.
Well, it's not for you to replace, you have to go before the chief judge. It's not your decision to replace.
He is right, the chief judge has to.
Which would be, since he's refused to be brought in regular. So you don't have the power to do that. Or they do.
What?
So what makes sense, and again, I'm not the legal counsel. But what makes sense is Mr. files his thing by 4:30, gives me a courtesy copy, I may want to reply to that. You make your decision on Friday, and then we can set a short hearing the very next week for the objection. That way, we're not running around, you know.
That is what has to happen. That's fine. So Friday, 1 o'clock
For the decision
for the
on my
decision
motion.
on this,
Thank you. And to set a future date.
a future date. Okay, so do we need to,
I should correct the motion, the earlier motion.
yeah, go ahead.
The earlier motion is not to reconvene for the hearing on the objection. It's to hear the motion to disqualify.
Motion.
Mr. Counselor, please call the roll.
Lawrence Taylor Ferry.
Aye.
Tim Brophy.
Aye.
Brian Concert, aye.
Motion carries. All right.
For clarification, now Friday is just for a decision on his motion.
Yes.
Correct.
And then we will, after that's decided, then we will set a date for the hearing on the objection.
Correct.
And Judge, I presume at that time, if, whether it's your three board members or a different chairperson, that the timeframes for parties to file briefs will be given prior to the hearing?
Yes.
If we talk about legal issues, so it would be helpful, I think, for the board to have a full legal decision.
Yes.
Well, if that's the case, if this is just a legal argument, then I don't understand why we're having a motion to disqualify. I'm very confused. If this is just a legal argument that I'm making in the objection, why are we asking for bias and everything else on factual matters and witnesses? If this is just a legal argument on what I'm asking for, which is what I said when I argued initially.
Because board members decide the legal argument, and we're entitled to a fair and impartial board member deciding that.
We will move forward with the motion that passed. Are there any other comments regarding this proceeding?
Is it public comment?
That's what I'm asking. Yes, sir.
Yeah, I would like to make a public comment. My name is Kirk Allen. What's that?
Please stand. Please stand.
Yeah, contrary to the
Hold
attorney.
on, I'd like to have this gentleman's address and where he lives to show that he is, whether or not he is.
You don't get that information. Be quiet, you don't have the floor. You don't have the floor.
You have the floor. You have the floor, Chairman. May I speak?
Did you state your name and information?
My name is Kirk Allen, and I will address the attorney's questions. This is a public meeting, and under the Open Meetings Act, the Attorney General has clarified you cannot require me to provide my physical address. That's because it's used as a form of intimidation. Contrary to the attorney's initial claim, the citizens absolutely have a right to speak, and it's during public comment.
Please continue.
In that process, I would urge that you convene a proper meeting where you put on the agenda to adopt the rules. There's been no agenda item to adopt rules. When you don't do that, you're violating the Open Meetings Act, and it's a very basic concept. And whoever the clerk is, I don't know if you're the circuit clerk or you're the county clerk, you folks know how things are to be done on an agenda. You can't act on anything unless it's on the agenda, even though this is an electoral hearing. I would just ask that you follow the Open Meetings Act properly. Thank you.
John Kraft. I don't live in Will County. I don't have an interest in this contested election, but I'm speaking anyway. It's an open public meeting. I would again like to reiterate, maybe you place a new agenda for Friday, adopt the rules on that agenda and adopt them properly. Because if you don't adopt the rules properly, with them being placed on the agenda, you can't use those rules. They're invalid. Rules improperly adopted don't work. Just like laws that were never approved by the legislature and assigned into law by the governor, they are not laws. It's the same with this board. The rules not properly adopted in an open public meeting and on the agenda do not work. Thank you. And also, if you could, let the security know that I plan on coming to every meeting, and I don't want to have to go through 4 or 5 hours of emails and phone calls to bring my camera and cell phone into the next meeting like I had to last time. Thank you. And I appreciate that it gets squared away.
You're welcome.
Alicia Benford. During the recess, you said you went back to consult with the legal counsel. Can you give me the name of the legal counsel that you went to consult with?
Absolutely.
What's her name?
Connor
McCarthy
from DuPage County, State's Attorney's Office.
Connor McCarthy.
Yes, ma'am. Yes, ma'am.
Hi, Judy Wooten. I just am curious, I may have missed it, But when you came back, you made a motion to go into recess. I do not remember a motion ever coming back in to come back into session. I don't know if that's a point of order or whatever, but I did not hear you come back into session.
I don't think Robert's Rules requires it. I think it requires the chair to call the meeting to order, reconvene is all. That's my understanding of Robert's Rules. If anybody knows them better, please say.
Anyone else? Public comment? Okay, I'll make a motion to adjourn.
Second.
Mr. Conzer, please call the roll.
Lawrence Staley Ferry,
Aye.
Tim Brophy,
Aye.
Ryan Conzer, myself, aye.
Motion carries. We will reconvene then on Friday at 1. Thank you all for coming.